Hello everyone. So today I'm going to be refuting the advocate's claim of fact speech. In her proposition, she states that the North Dakota Access Pipeline has a significant negative effect on the local native population. In her speech, she uses three secondary claims. One, that DAPL poses as a major threat to the environment. Two, that DAPL will harm the relationship between the tribes and government entities as a result of transgression of Native American values. And three, the DAPL will violate treaty rights. In the first claim, she states that the DAPL poses a major threat to the environment. Though danger to the environment is present in the case of the DAPL, it fails to respond to its effects on the local Native American population. According to the United States Department of State, out of the 9 threatened, endangered, and captive species mentioned by the advocate, only the American burying beetle is adversely affected by the construction of the pipeline. The department and the United States Fish and Wildlife Services are coordinating to keep wildlife and fisheries safe from environmental damage. Otherwise, the local Native American tribes are unaffected. In their second point, the advocate referred to an increase of reliance on fossil fuels, which begs the question, what does methane gas or greenhouse gases have to do with them? Greenhouse gases, or global warming, is a global phenomenon that not only affects the Sioux tribe, but to every living being. Therefore, the point diminishes its connection to the major claim of how it affects the local native population. In addition, the advocate seems to suggest that the corporation behind the Keystone XL pipeline is making improvements to minimize the damage done by an oil spill should the pipes leak. With these points taken into consideration, the Sioux tribe would be unaffected by the changes brought on by the DAPL. For the second claim, the advocate states that the DAPL will harm the relationship between the tribes and government entities. However, the advocate uses points of value, in which the claim lacks an opposing standpoint that suggests otherwise, that the relationship between tribes and government entities will improve. Having said that, it is ethically unjustified to suggest alternative standpoints of whether to dig up ancient Native American burial grounds, or to state that water serves without meaning to the Sioux tribe. Lauren Kimmel, an associate editor for the Michigan Journal of International Law, notes that the relationship is plagued with a history of broken promises. Through the Supreme Court rulings, especially in the cases of Lone Wolf v. Hitchcock and United States v. Sioux Nation of Indians, the government was consistently favored in both counts. In the Lone Wolf v. Hitchcock case, the Supreme Court ruled that the United States may temporarily relieve provisions until further notice. Jackie Rand, a history professor in American Indian and Native Studies, stated that this is in response to allegations made against the United States with note when provisions of food and clothing were not adequately provided in accordance to the Medical Law Treaty of 1867. This has led to Sioux attacks outside of reservations in 1871. In the United States v. Sioux Nation of Indians, under the account of Judge Harry Blackmun, the Supreme Court ruled that the United States acted in bad faith against the Sioux tribe in seizing the Black Hills and offered monetary compensation of $1 billion. However, the Sioux tribe demanded to have their lands back, which leaves the ruling outcome in question. As for the pipeline itself, given what the advocates had stated in their first claim, it is now a dilemma between favoring the environment and cultural sanctities. Regardless of what decisions are made, the relationship will continue to brace against one another. For the third claim, the advocate claims that the DAPL will violate treaty rights. Considering what was stated in both the first and second claim, it becomes confusing as to whether the Treaty of Fort Laramie still stands. Lauren Kimmel, whom the advocate quoted, stated that the treaty does in fact offer the Sioux tribe the rights to the land. However, in this historical sense, the Superior Court rulings, as previously stated, have reinterpreted the articles in the Treaty of Fort Laramie of 1868, especially in the United States of the Sioux Nation of Indians case. Additionally, the Sioux tribe raids on Americans in 1871 and the Black Hills Gold Rush of 1874 acted against the articles transcribed into the Treaty of Fort Laramie. Ultimately, it becomes difficult to discern if the claims holds true with the assumption that the treaty rights remain as intended. In conclusion, There's insufficient amounts of evidence suggesting that the dapple negatively impacts the local native population. First, given the circumstances, there's a lack of correlations between the dapple's influence on the environment and the Sioux tribe's well-being. Second, the cultural values upheld by the Sioux tribe prevents any argumentative standpoint that will point out the benefits of the construction of the dapple. Lastly, the Treaty of Fort Laramie may be outdated as articles have been infringed upon from both the United States and the Sioux tribe. That's about it.
All right, well, you labeled the claims pretty clearly at the beginning. When you get to the exact issues, I'm not sure that you're quite as efficient at that. You kind of get on the fossil fuel issue and talk about, the relationship to the native population and talk about we've got tools to prevent or the things that are being designed to prevent oil spills or compensate for them. I'm going, okay, so this is a good thing or is it a bad thing? How does that support the advocate's position? How does it oppose the advocate's position? I'm not sure. It's a piece of information. It feels like it's relevant, but until you make a claim from it, it really feels like it's sort of out of place. There is an argument that suggests that this whole first section is really based on a point of value rather than an issue of fact. And if that's the case, then tell us what the value is and why judging it by the standards that are being presented is problematic. On the issue about whether or not the treaty still exists, you've got a couple of historical examples that you point to. You've got Supreme Court rulings that have judged on these particular issues. I think the implication was that the rulings came down in favor of the U.S. over the tribal governments. That was the inference that I was drawing here. So if the court's an independent arbiter of what is going on here, then I think that we've got a standard that applies here, and you could say this is, according to the way things have been interpreted by the legitimate authority, everything's copacetic here, and we don't really have to worry about these kinds of things. It's just a misunderstanding or some other kind of problem that's going on. On the at the end, I thought that you had a pretty good summary of what the points were. Sometimes the claims are clearer in the summary than they are on the individual points, and that would be something that maybe you could fix. Maybe sometimes remind us at the end of each point what it is that you are trying to accomplish with the evidence that you presented on those individual points. All right. Thank you.